right, good morning, everyone. I'm Judge Blake Adams. We're here for the small claims non-jury trial docket this morning. And we have one case on the 9 o'clock docket this morning, Paul Thompson v. Marco Yacht Sales, LLC, 20 SC 1510. Could I have the plaintiff introduce themselves, please?
Yes, my name is Paul Thompson.
Thank you. And could I have the defendant introduce themselves, please? I think you're on mute. Let me see.
Christopher Stahl, representing Marco Yacht Sales.
All right, thank you, Mr. Stahl. And Mr. Stahl, for the record, could you identify your relationship with Marco Yacht Sales?
The CEO.
Thank you. And the spelling of your last name, S-T-A-H-L?
Yes, sir.
Very good. All right. Give me one moment here. All right, we're here for an allegation of negligent damage to Mr. Thompson's starboard cowling of his boat engine. Before we begin, let me ask you, Mr. Stahl, would you like to have an opportunity to speak with Mr. Thompson to try to reach settlement before we begin the trial?
No, but I do need to make the court aware that there was an order on communication from Tamara Lynn Nicola on April 29th that no communication with this court with Mr. Thompson through a judicial assistant or the judge without assistance of an attorney licensed by the Florida Bar. I do have that case number if you'd like a copy of that.
That's okay. I'm aware of that order, and that order does not affect this case.
Okay.
Okay. So with that in mind, would you like an opportunity to speak with Mr. Thompson before we begin? I could put you in a breakout room.
We can proceed.
Okay. All right. If I could have you both raise your right hands to be sworn. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Very good. Thank you. All right. So just to give you a brief introduction of how the trial will work, I'll give you both an opportunity to provide an opening statement if you would like. An opening statement is just an opportunity to tell me what evidence you plan to present. An opening statement is not evidence in and of itself. However, you can waive your opening statement and just go right into your own testimony and present your evidence if you'd like. Once the plaintiff has had an opportunity to present testimony, evidence, or any witnesses that you may have, the defense, in this case, Mr. Stahl, will have an opportunity to ask questions of you regarding your testimony or the evidence that you've presented. Once that's completed, then Mr. Stahl, you'll have an opportunity to present your testimony, evidence, or any witnesses that you wish to present. And Mr. Thompson will have an opportunity to ask questions regarding that evidence. And then Mr. Thompson, you'll have an opportunity to present any rebuttal testimony or evidence based on the defense's testimony and evidence. I did obtain copies from the clerk of your exhibits, Mr. Thompson, that were admitted at the hearing back on March 24th, so I do have those. And Mr. Stahl, I do have the exhibits that you filed with the court back, I believe, in March or February. All right, any questions?
Judge, I haven't received anything from Marco Yacht Sales. No physical evidence or witnesses or anything. I have received nothing from Marco Yacht Sales.
Give me one moment here.
We can ask Chris Stahl, did he send anything to me?
Mr. Stahl, the 7 pages of exhibits that you submitted back on March 15th, did you provide a copy of those to Mr. Thompson?
Yes, sir.
Okay.
That's
All
not
right.
true.
Mr. Thompson, I suspect they're probably things that you already have. The first 3 pages are an invoice to you in the total amount of $2,409.98. The next page is an email from Mr. Stahl to you dated May 19th. The next page is a copy of a contract with Safe Harbor, looks like. And then there's a written notice for a demand for payment and a written notice regarding a trespass warning. Are you familiar with those documents, Mr. Thompson?
Yes, I am.
Okay.
But I never received them from Chris Stahl.
Okay, but you previously received them.
I know of that. I know of some of them, not all.
Give me 1 second here. All right. No, I don't think I'm sharing the right page. All right. Does this invoice look familiar, Mr. Thompson?
Yes.
And it's 3 pages.
Correct.
And then here's the email from May 19th.
Okay, I have a copy of that, but it doesn't show my response to it. This I have no knowledge of, no copy of.
You don't have a copy of this?
No, I do not.
Signed it. You didn't receive
No.
a copy when you signed it?
No, I did not.
There's this demand for payment.
Yeah, this demand for payment has absolutely nothing to do with this case. It was something else.
Well, that'll be discussed if it's tried to be admitted.
Sure.
All right, and then this trespass warning looks like.
Oh yeah, he threatened me that if I came back.
Okay, we're just
on the property, yeah.
discussing whether or not you received.
Yes, I do have. Yes, I do have that.
All right, so the only thing you haven't received is
A copy of this, of hauling the boat out
all right.
at the marina, Calusa Marina.
All right, since you didn't receive a copy of this, you have 2 options. We can either continue the case.
We'll continue. We'll continue.
You're moving for continuance.
Yes.
Any objection, Mr. Stahl?
No, sir.
Okay, let me look at my calendar.
I wish to continue.
Continue the case or continue with trial?
Continue with the case.
So, all right, let me rephrase the question. Do you want to go ahead with the trial today?
Yes,
Okay, all right. So you're waiving any discovery violation?
correct.
All right, very good. All right, let me figure out how to stop sharing here. Okay. All right, Mr. Thompson, you may proceed with your testimony then.
Okay. I brought my boat in for 100-hour service to Marco Yacht Sales on Thursday, May 14th, 2020 at 9 a.m. Both my engine cowlings were in perfect condition. On Friday, May 15th, I picked up my boat and returned to my marina in 20-knot winds and heavy rain. After arriving at 4 p.m., I noticed what appeared to be a scratch or a small crack on the starboard cowling. Because of the heavy rain at this time, I did not wash down the boat or cover the engines as I usually do. The covers are in Exhibit G. On Sunday morning, May 17th, I went to my marina where I have a water slip to clean the boat and cover the engines. I then noticed that this scratch was much worse than when I first thought. I have exhibits B, C, D, E, and F. I called Marco Yacht Sales and left a message for Chris Stahl that I have damage on the starboard cowling. I believe that since my boat was in his possession at Marco Yacht Sales, they would be responsible for this damage. It appears this damage was caused by some object that could have dropped on it, or the cowling was dropped, and that's Exhibit F. On Monday, May 18th, I went to Marco Yacht Sales to show pictures of the damaged starboard cowling. Mr. Stahl told me that a 18,000-ton high-low boat forklift hit the starboard cowling, or I backed into a pole. On Tuesday, May 19th, I brought the damaged cowling to Chris's office so he could examine the damage. Mr. Stahl would not come out to my car to view the damage. He stated that he took pictures of the boat when it left. When I asked to see the pictures, he told me to get the F out of his trailer. And he threatened me, which was Exhibit K and Exhibit M. I had recently repainted these cowlings on December 9th, 2019 at a cost of over $1,200. We also purchased special covers to protect them. As I slip on these covers at the end of a day, I examine the engine for any imperfections. On Thursday, June 4th, the starboard cowling was repaired at a cost of $300, and I now expect Marco Yacht Sales to be responsible to pay for these. That's Exhibit H.
All right, Mr. Thompson,
Yes.
you referenced several exhibits here. Exhibit and Mr. Stahl, did you receive copies of Mr. Thompson's exhibits?
I'm not aware of Exhibit K. I don't have a copy of that.
All right, we'll go through each of these. All right, Exhibit B is a photograph of the engines of the boat in the water. Are you moving to admit that into evidence, Mr. Thompson?
Yes.
Mr. Stahl, any objection?
No.
All right, Exhibit B will be admitted. Exhibit C is another photograph of the boat with the engines out of the water. Are you moving to admit Exhibit C? Mr. Thompson?
Yes.
Any objection?
No, sir.
All right, Exhibit C will be admitted. Exhibit D is an up-close photograph of the starboard side engine. It looks like it has a hand-drawn circle on it, I guess indicating where the damage is. Any objection to, or are you admitting?
Yes.
Moving to admit, all right. Any objection to Exhibit D?
No.
Exhibit D will be admitted. Exhibit E and F are again photographs of the starboard engine that are zoomed in, and both of these have circles on them to indicate where the damage are. Are you moving to admit those, Mr. Thompson?
Yes. Yes.
Any objection to Exhibits E and F?
No.
Exhibits E and F will be admitted. Exhibit G is a picture of the back of the boat with the engines covered. Are you moving to admit Exhibit G?
Yes.
Any objection?
No.
Exhibit G will be admitted. Exhibit H is an invoice from Painter George Custom Coatings regarding repair of compression cracks on upper portion of cowling, cutting of cracks, filling cracks with epoxy, fairing compound followed by primer. The invoice is in the amount of $300. Are you moving to admit Exhibit
Yes.
H? Any objection?
No.
Exhibit H will be admitted. Exhibit I is a Verizon phone bill. Are you moving to admit Exhibit I?
Yes, I am.
Any objection?
No.
All right, Exhibit I will be admitted. Exhibit J is an invoice from Naples Boat Yard. Any objection?
No.
Exhibit J will be admitted. Exhibit K is the written trespass warning, which you have in your exhibits. Mr. Thompson, are you moving to admit Exhibit K?
Yes.
Any objection to Exhibit K?
No.
Exhibit K will be admitted. Exhibit L is a letter to you, Mr. Stahl, or an email.
It was in response to his email.
All right, looks like it's, I'm not sure the date on it, May 19th possibly,
Yes, on the bottom.
which also includes, looks like the emails that you included in your exhibits, Mr. Stahl. Any objection to Exhibit L?
No.
Exhibit L will be admitted. Exhibit M is a photograph. Mr. Thompson, can you tell me what this photograph is of?
It's a photograph of Mr. Stahl's trailer at Calusa Marina.
All right. Are you moving to admit Exhibit
Yes.
M? Any
Yes.
objection? Any objection, Mr. Stahl?
No, sir.
All right. Exhibit M will be admitted. And then there's Exhibit N. I believe this is a photograph of the lift.
It's an 18-ton high-low that lifts
Okay.
boats into the water.
All right. Are you moving to admit that?
Yes.
Any objection?
No, sir.
All right. Exhibit N will be admitted. All right. Any additional testimony, Mr. Thompson?
Well, no, I have questions for him, but
Well, you'll have an opportunity for that.
okay.
All right, Mr. Stahl, any questions of Mr. Thompson in light of his testimony and the exhibits that were admitted?
No, sir.
All right. Let me just clarify something, Mr. Thompson. What is the amount of damages that you're seeking?
$300 for the repair of the cowling and plus court costs.
And how much were your court costs?
It was $90 for filing and $40 for a sheriff to submit to Mr. Stahl, a total of $430.
Mr. Stahl, any questions for Mr. Thompson in light of the court's questions?
No, sir.
Okay. All right. Mr. Stahl, it's your opportunity to provide testimony, admit any evidence, or call any witnesses.
Okay, on May 14th, we completed a service for Mr. Thompson on his motors. He picked up the boat and he returned Tuesday, May 19th, claiming damage. The damage that he described, he did not have his engine cowlings with him for me to look at. He just had a photo. And I reminded him, you know, he had signed a waiver of risk or damage with the marina, safe harbor. And after that, I did send him an email regarding our conversation. And he immediately tried to collect from the marina, I believe over a 2-week period. And then he started coming back to my office after he saw that that was not going to happen. And he returned 3 times. The 3rd time, he had threatened my employees and the business, and that's when we asked him to leave. We also submitted the no trespass warning at that point in time. And to return 4 days after you've identified some damage, to me, that's not right. He should have come back immediately.
All right, anything else, Mr. Stahl?
No, sir.
All right, do you want to admit any of the exhibits that you provided the court?
Omit them?
Admit them. Do you want?
Yeah, yes, sir. Yeah.
All right, I'm going to mark the invoice as Defendant's Exhibit A. Any objection, Mr. Thompson, to the invoice being admitted?
No, no objection.
All right, Defense Exhibit A will be admitted. I don't really see a reason to admit the email. It's already been admitted as part of the plaintiff's case. Defense Exhibit B will be the safe harbor contract. Any objection to that, Mr. Thompson?
No.
All right, Defense Exhibit B will be admitted. The demand for payment will be Defendant's Exhibit C. Any objection to that?
Yes, I do object to that because it has nothing to do with this particular case. It was for a $604 payment on service and had nothing to do with the cowlings or anything to do with this case at all.
Response, Mr. Stahl?
You can remove it, Your Honor.
All right, Exhibit C will be withdrawn. And then the trespass warning was already admitted under the plaintiff's case, so I don't see a reason to admit that. All right. Any additional testimony, Mr. Stahl, that you'd like to provide regarding your exhibits?
No, sir.
All right. Mr. Thompson, do you have any questions regarding Mr. Stahl's testimony?
Yes, I do.
Go ahead.
He claims that 4 days I did not do anything, and I have proof.
Mr. Thompson, that doesn't sound like a question for Mr. Stahl.
Oh, okay. Did I not come on Monday morning and show you pictures of the damage?
No, sir. It was Tuesday, May 19th at 9 a.m.
Okay. Did I come the next day, Tuesday, and bring my cowling to show you the damage, and you did not come out to look at the cowling and told me to get the F out of your office?
Again, you showed up Tuesday, May 19th at 9 a.m. was the first time that you had showed up, sir.
I disagree with that, but the judge will rule on it, I guess. Because on Monday I brought in pictures, and then Tuesday I brought in the cowling, and you
Mr.
did not come
Thompson.
out and take a look. Yeah.
Do you have any more questions for Mr.
Yes, I
Sproul?
do. Who worked on my engine? Who worked on the engines?
One of our
What was it?
technicians.
What was his name?
That doesn't have anything to do with the case.
Was the mechanic that worked on my engines, was he an employee of Marco Yacht Sales?
Yes, sir.
When did you hire him?
Yeah, I'm not going to answer that.
When is he still working for you?
Yeah, I don't need to answer that either.
Was the mechanic qualified to work on Yamaha engines?
He's a master tech.
When did he leave your employment, and was it a pleasant departure?
I'm not going to answer that question. It has nothing to do with the case.
Were you working on May 17th, Sunday, when I called and told you there was damage?
Yeah, we're not open on Sundays, sir.
When did you listen to my 2-minute phone conversation that I made on Sunday, May 17th? And that's on Exhibit I.
Unknown. I don't know what that question means.
When I stopped in on Monday, May 18th, and showed you pictures of the damaged cowling, did you blame the 18,000-ton forklift for the damage?
Again, you came to our office Tuesday, May 19th.
Did you speak with Ivan Gaza, and an owner and manager of Calusa Marina, to verify the damage of the cowling?
Has nothing to do with the case as you signed the waiver with Safe Harbor.
Wouldn't a 18,000-ton high-low leave grease and much more damage than that little scratch that's on the cowling?
No, sir, as there's protected surfaces on those forklifts to pick up boats, and they do not leave grease.
When I brought the damaged cowling to Marco Yacht Sales on Tuesday, May 19th, why did you not come out and take a look at the damage?
Because you did not have the cowling with you.
I most certainly did have the cowling with me. Did you claim that you had pictures of the boat when it left the marina, or was there a video you told me you had?
The marina records 24/7, and the marina manager said he had a video of the boat when it left the marina.
Do you have a copy of this?
No, sir.
When I asked to see pictures,
I'm sorry to interrupt. Could I need one moment. I'm the duty judge today, and I think there's a warrant here for me to sign. Give me one moment. We'll be in a brief recess.
Okay, Judge.
Thank you. Okay, I apologize for that. Go ahead, Mr. Thompson. I think you're on mute.
Okay. When I asked to see the pictures you claimed that you had, did you tell me to get the F out of your trailer?
No, sir, the marina had the video. I do not own that video. Safe Harbor does.
When I asked to see him, did you tell me to get the F out of your trailer?
No, sir.
Did you know that I had recently repainted these cowlings in December for $1,200?
That was unknown to me.
Did you have authorization to send a certified letter notarized by your wife that I could not enter the Calusa Marina, or you would have me convicted of a crime of trespassing?
I'm going to object as to relevance. Next question.
Oh, that was one of the exhibits. Did the Marco Island police contact you and tell you that you could not keep me from entering Calusa Marina and that your wife was unauthorized to notarize a husband's statement?
I'm going to object as to relevance.
Okay.
Next question.
Okay, after paying you more than $3,000, why does this situation have to end up in small claims court?
I'm going to object as to relevance. Next question.
Okay. Did the mechanic grease the shafts on both engines? That's in Exhibit L.
That has nothing to do with the cowling damage.
Well, it has to do with the Exhibit L of your email that you refused to go back and grease it and fix the hours on my meter. I have no further questions, Judge.
All right. Mr. Thompson, any additional testimony you'd like to provide in light of the questions that were asked of you?
Questions that were asked of me?
I'm sorry. I'm sorry. I said Mr. Thompson. I meant Mr. Stahl. Mr. Stahl, do you have any additional testimony you'd like to provide in light of the questions that were asked of you?
No, sir.
All right. I have a couple of, the court has a couple of questions. Mr. Stahl, what's your company's standard policy of reviewing items that are brought in for repair prior to releasing to the owner?
We do a visual walk around, and if we do see any damage, we will take pictures and make them aware of it.
And was that done in this case?
I can't answer that. I do not know if the tech did that. It's the tech's responsibility to notify any damage. So I'm assuming there was no damage when the boat came in.
Did the technician report anything to you?
No, sir.
What is your company's policy regarding damage if detected?
We will immediately review it and then notify the customer.
And is it your testimony today that no damage was detected and so there was no need to notify Mr. Thompson?
That is correct. When the vessel left my service bay, there was zero damage reported.
Mr. Thompson, any questions for Mr. Stahl in light of the court's questions?
No, Your Honor.
Okay. All right. Any further testimony or evidence you'd like to provide, Mr. Stahl?
No, sir.
Mr. Thompson, any rebuttal testimony or evidence you'd like to provide in light of the defense's testimony and evidence?
Basically, he's been untruthful.
I'll take that as a no.
No.
All right. All right. Any final argument you'd like to provide, Mr. Thompson?
I cannot understand why a business would not understand my point of view and research rather than telling me to get the F out of his trailer. I'm very disappointed. I never will use Marco Yacht Sales for any other work to be done. And I feel that he's responsible, and it's been over a year now that I've laid out this money, and the damage was caused by Marco Yacht Sales.
All right. Thank you, Mr. Thompson. Mr. Stahl, any final argument you'd like to provide?
Yes, again, the damage was reported on May 19th, and the damage was directed towards the marina's forklift on that date. And he went directly after the marina and did not have any complaint with Marco Yacht Sales at that time for the forklift damage. So, that's all I have.
All right. All right. Give me one moment and I'll be back with my ruling.
Thank you, Judge.
Thank you. All right, I'm back. We're back on Paul Thompson v. Marco Yacht Sales LLC, case number 20 SC 1510. Having heard all of the testimony from the parties, as well as reviewed all of the plaintiffs and defendants' exhibits that were admitted into evidence, the court finds that the plaintiff, Mr. Thompson, in this case, has provided insufficient evidence to show that Marco Yacht Sales LLC caused any damage due to negligence to the engine cowling of Mr. Thompson's boat. In fact, the evidence or the lack of evidence in this case is that the boat was not inspected prior to Mr. Thompson taking the boat from the yacht sales company after it being serviced. And it wasn't until a day later that Mr. Thompson noticed the crack, and that was after having used the boat. So the court finds again that there was insufficient evidence to prove negligence on the part of Marco Yacht Sales LLC. Accordingly, the court finds for the defendant. All right, thank you both. We'll get the final judgment out today.
It's terrible, Judge. Terrible.
Thank you, Your Honor.
Terrible.
Well, Mr. Thompson, that's the ruling of the court. Thank you both.
Thank you.
I don't believe this.
Now I know why this guy.
All right, Madam Clerk, we've got another case set. Let me bring those parties in. Give me 1 second here. All right. All right. Good morning. Mr. Fisher, can you hear me? You'll have to unmute your device. All right.
How about?
I'm doing well. How are you, Mr. Fisher?
I'm fine.
Good, good. All right. We don't have the plaintiffs with us yet. I just got done with another case. Give me 1 moment. I'm going to take a brief recess. Okay, Mr. Fisher?
How many minutes, Your Honor?
I'm not sure. I'm duty judge this week, and I was notified that I've got a warrant I have to review, so it'll be a few minutes.
So a bathroom break would be okay?
That'll be fine. Do you want me to put you back in the waiting room until I'm ready to begin?
You're in charge, whatever you want to do.
Okay, I'll go ahead and do that.
Thank you.
All right, thank you. All right, I'll be back. All right, we're back. I've got Mr. Fisher with us, and this is case of Ryan Lieben v. Dale Fisher, case number 20 SC 1648. Mr. Fisher, are you able to unmute your device?
There we go.
All right, perfect. All right, well, I've got one other person in the waiting room. I think it's for the next case, but let me bring them in just to make sure, because I don't see anyone here for the plaintiff. And good morning, Ms. Rousseau. Can you hear me?
Yes, sir, I can.
All right, did I pronounce that correctly?
You did.
All right, very good. And you're here on the Naples HMA case v. Susanna McHugh, is that correct?
That is correct.
Okay, all right. I'm gonna put you back in the waiting room for just a few minutes, okay?
Thank you, sir.
All right, thank you. Okay, all right, well, I don't have anyone here for the plaintiff, so I'm going to dismiss the complaint against Mr. Fisher. I'll do an order for that today, Mr. Fisher. Now, that doesn't necessarily mean that the case will go away. I do note that the plaintiff is represented by counsel. I don't know why counsel is not here, so I suspect we'll probably be hearing a motion to vacate the order of dismissal, but you know, I don't know. But I'm going to go ahead and dismiss the case as of right now. That'll be without prejudice. Any questions, Mr. Fisher?
No, Your Honor. None.
All right. Thank you for your patience here this morning, Mr. Fisher. Have a great day.
You too. Thanks.
Thank you. Okay. Let me write that case number down. All right. Got about 4 minutes before 10. I'm going to step away and I'll come back at 10. Thanks. just waiting on what appears to be Ms. McHugh's connection to establish.
Hello?
Ms. McHugh?
Yes. I was having trouble on the audio, so I just called in.
Okay. Do you have the ability to do video?
I have you on the screen, but for some reason, my microphone's not working, so I can see you. You just can't see me, I guess. I'm up there. Can you see my name up there?
I can.
Okay.
However, I've got to be able to see you in order to take testimony from you.
Okay. Well, can I ask you a question before we begin?
Yes.
And I can try and figure it out. I'm in the process of filing bankruptcy, so I don't even know why I received this, because I did notify Lotain.
Ms.
Yes,
Jordan?
Your Honor, we've had previously scheduled a trial at which she requested a continuance in order to file bankruptcy. And
It was just last month.
Trial date was reset. I'm not sure at whose, let's see, if it was the court on its own motion that set a new trial date, or I don't recall asking for a new trial date in our file here. So, but we haven't received any notice of bankruptcy, so we proceeded as normal.
And the court has not received anything in the court file regarding a notice of bankruptcy.
Well, can I say something, Judge?
Go ahead.
My attorney said I won't have a docket number for at least 45 days, and that's what I believe you need to have.
I'm showing that on April 9th, the pretrial conference was held, and based on the pretrial conference tracking sheet in which request for non-jury trial was marked, that's why the court set this for non-jury trial.
Okay.
Ms. Jordan, you're representing the plaintiff in this case. How would you like to proceed?
Ms. McHugh, has your attorney filed all of the bankruptcy paperwork and you're just waiting to get on the docket for the court?
Yeah, as I understand it, that I need to have a docket number, which provides you with a list of all the creditors, and you're on there. And then it goes, I don't know if it goes to bankruptcy court, wherever it goes into the court system, I'm not sure. I'm sure it's bankruptcy court. And then I have a date where I have to appear. So she's in the process of working on it, and I have provided your law firm with her contact information. If you need it again, I can give it to you. That I have no control over how long it's going to take.
Well, we have, I guess, it's not my place to ask for continuance. We are ready to proceed with trial if that is your Honor's decision. If Ms. McHugh was interested in a consent judgment,
I can't enter into a consent judgment, otherwise the bankruptcy will be null and void, because it's my understanding I cannot make any arrangements. As if I pay one creditor over another, then my bankruptcy would be canceled. That's what I understood.
Well, consent judgment isn't a payment plan. It's just saying that the court will enter a judgment and you agree to that. I don't know how that
why
affects.
would I-
I'm not a bankruptcy attorney, so I don't know how that affects the bankruptcy case.
Yeah, I believe it does. And the other thing is, when we had our last Zoom call, I understood that your office would ask for a date in the in the future, like 6 months from now. So that's why I was surprised I received a notice for pre-trial, because I wasn't expecting for this to happen so fast.
I'm looking at the order from May 7th.
We're just in June.
The court
It's
took this up on their own motion. This wasn't my firm requesting a trial.
That's
So,
correct. It was the court's own motion.
we would not
Okay.
object to another continuance to allow time for the bankruptcy, but that's at your honor's discretion.
Give me one moment here.
Of course.
Ms. McHugh, are you requesting a continuance?
I would, Your Honor.
All right, I'm going to go ahead and grant the defendant's request for a continuance. I'm going to continue this to July 7th at 10 a.m. That'll be for a non-jury trial. Ms. McHugh, you should probably talk with your bankruptcy attorney about this if you haven't already. That way they can file with the court a notice of bankruptcy.
Okay.
Which would stay the case. And if the court hasn't received that, we'll go ahead and continue with the non-jury trial on July 7th. And did I say 10
Okay.
o'clock? 10 o'clock.
Yes.
Okay, all right. I'll
Thank
go
you, Your
ahead
Honor.
and issue an order continuing this case to July 7th at 10 o'clock. That'll be via Zoom.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right. Thank you both.
Ms. Russo.
Yes,
Thank you,
ma'am.
Ms. Russo.
Thank you. Have a good day.
You too. All right. Amanda, I'll go ahead and do an order for that. And then write down the case number. Okay. What time is our next one? 11?
Yeah, it's on 11.
Okay. I'm going to go ahead and just log out and then I'll log back in then.
Sounds good.
Okay. All right. And I have the exhibits from the first trial. Do you want us to send them over or?
Could you send them over?
Okay. Well,